Greetings, I'm Glenn Witecki from the Witecki Law Office in Schenectady. The primary areas of practice that we focus on here are estate planning, elder law, business succession planning, and real estate matters. And we often try to encourage someone to do a trust because doing a will, it gets the job done, but whenever you pass your property by will, there's always someone who has a right to challenge your will. The people who can challenge your will are the people who would inherit your property if you didn't have a will. And I encourage you to look at other videos on this site to tell you who those people are and the grounds they can use to challenge a will. But here's the difference between how a will works and a trust works. When you do a will, and first of all, a will only controls assets in your own name with no co-owner, no beneficiary named on them, and that are not in a trust. But whatever those assets are, they pass under your will, and when you pass away, the people who would have a right to object to your will, who are the ones who would inherit if you didn't have a will, you need their signatures before the judge approves your will and gives authority to the executor or executrix of the will to manage your estate. So that takes time to do that. And if someone decides they want to object, or even if they don't want to consent and sign off on the will, they can hold up the process by requesting a year's worth of medical records, financial records. They can demand that they have a hearing in court where they put witnesses on the stand who were the witnesses to the will. They can demand to cross-examine on the witness stand the drafting attorney for the will. And they can put the estate through all that process. By simply having done a revocable trust, where the same individual, naming the same person to handle their estate, then transfers their assets into the trust one by one, there is no need to go to the court because the trust does not have to be administered through the court system, and there really is very little, if any, chance of filing objections, holding things up, costing the estate lots of money, getting financial and medical records, and so forth. So look, if you have a situation where, let's say you're a single person with 3 children, and you leave everything equally to the children, a will is going to work just fine because no one has any real grounds to object. But let's say you don't have any children and you have siblings. Well, if you're single with no children and your parents are deceased, your property without a will is going to go to your siblings. So if you have a will, your siblings are the one who can challenge the will. So let's say that's your scenario, but you're closest to one sibling. You want to leave them your whole estate. But you still need your other siblings to sign off on the will. If they decide not to do that or to challenge the will, they can hold things up considerably. So that's a situation where you want to strongly consider a revocable trust. Once again, if you've got 3 kids, you're treating them equally the same way with a will as they would inherit your property without a will. There's no grounds to object. Nobody's going to. A will works fine. But where you're leaving property to less than all of the people who would inherit without a will, or if you're giving some people more inheritance than others, strongly consider a revocable trust to reduce or eliminate the chance of a challenge to a will and to expedite things as quickly as possible. Thank you.